Premises liability cases are cases involving things like slip and falls, trip and falls, and other incidents where someone is injured as a result of someone else's negligence on their property. It could be a property owner, a property manager, it could be contractors or builders, things like that, but those who maintain premises and create hazardous conditions that then cause injury. We certainly preach self-help in every kind of case, and so in premises cases, probably more so than other types of cases, it's really important to observe evidence in the condition or hazardous condition, really in the way it looked at the time our client was injured. So we definitely encourage folks to take photographs. It could be, let's say, snow and ice on a sidewalk, like outside an apartment complex. It could be, a big hole, in the ground, things like that, that the landowner failed to fill in. It's a variety of different things, but it's important before that condition is remedied to go ahead and capture what that condition looked like. I think it's probably just human nature that folks, when they are guilty or when they are responsible, to try to shift the blame onto someone else. But Virginia is nice because that owners, for example, have a non-delegable duty, so they can't shift the blame onto others. Others may also bear responsibility as well. And Virginia is what's called a joint and several liability state. So, if we were to file a lawsuit in a premises case, we might file suit against the owner and a property manager, maybe a contractor or other third party who is also responsible for creating that hazardous condition. But owners, again, they can't just shift the blame onto others. Ultimately, the buck stops with them. In auto cases, there have been so many types of different sort of auto cases: rear-end collision, side swipe, head-on collision. In premises, the facts are different every time. And so as a consequence, you really have to be really adaptable in terms of trying to figure out how best to really improve your case. So in an auto case, for example, you don't need experts, liability experts, to prove that a guy was at fault who hit you from behind. In a premises case, typically, overwhelmingly, really, we hire experts, engineers, architects, who oftentimes will look at things like building codes, fire safety or electrical codes, things like that, in order to show that the owner or the other person or company responsible, violated some statute or regulation, or otherwise, violated their duty of care to the public in harming our client. Another thing that we do in terms of investigating the case is almost invariably when we receive a phone call about a premises liability situation, we will send out correspondence to put the owner or the other party on notice, but we'll send out what's called a spoliation of evidence letter. And what that means is that really there is a duty to preserve evidence, and spoliation really means somehow either willful or negligent destruction of evidence. And Virginia law has changed over the years so that there are potentially real consequences if, let's say, a landlord destroys, let's say, surveillance video showing a hazardous condition that harmed the tenant. If they do that and it was willful, again, there can be very serious sanctions, including even dismissing defenses and other penalties. And so it's really important for us to also make sure that they, just like with the photographs with the client, that we also tell the owner, for example, to go ahead and preserve evidence on their end as well.